Today my topic is on the justiciability of economic, social and cultural rights. Introduction. There is no formal or strict definition of what constitutes an economic, social and cultural rights. Thus, the economic, social and cultural rights deal with basic human rights such as right to work, the right to equitable and favorable labor conditions, the right to social security, the right to a decent standard of living including adequate food, clothing and housing, the right to adequate health care, and the right to education. The collective rights to a clean natural environment and the right of development also belong to the category of economic and social right. As such, the economic, social and cultural rights are mentioned in the International Covenant on Economic, Social and Cultural Rights 1966 as outlined in the Universal Declaration of Human Rights 1948. The same has also been stipulated in the Part 4 of the Constitution of India under the banner of the Directive Principles of State Policy. In addition, the state parties to the International Covenant on Economic, Social and Cultural Rights have undertaken to take steps individually or through international economic and technical assistance and cooperation to the maximum of their available resources for achieving progressively the full realization of rights recognized in the present covenant. States have also exercised without discrimination of any kind as to the race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. The position of economic, social and cultural rights is almost same as that of the Directive Principles of State Policy under the Constitution of India. Article 37 of the Constitution provides that the provisions contained in Part 4 shall not be enforceable by any court. Rather, these principles are fundamental in the governance of the country and it shall be the duty of state to apply these principles in making laws. However, these rights are the inherent and inalienable rights of every individual being born in the human society, and they are also considered to be the second generation of human rights. United Nations endeavors. When the Universal Declaration of Human Rights was adopted in 1948, the United Nations General Assembly made no attempt to classify or restrict the types of right to be included within this instrument. It simply included all those rights which were considered necessary to secure the dignity and worth of every individual. This catalogue of rights under the Universal Declaration of Human Rights includes what are generally referred to as civil and political rights, such as the right to life, freedom of expression, and so-called economic, social and cultural rights, including the right to work, the right to education, and the right to participate in cultural life. As a result of divisions of views between the Western and Communist states, the United Nations was circumscribed to draft two treaties to accommodate the political realities of the day. This is the reason why we have the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights as well, on which the Charter is based. Economic, social and cultural rights are incorporated in the International Covenant on Economic, Social and Cultural Rights, which was adopted by the General Assembly on 16 December 1966 and entered into force on 3rd January 1976. In pursuance of the general obligation undertaken by the member states under the United Nations Charter to ensure higher standard of living, full employment and conditions of economic and social progress and development, solutions of international economic, social, health and related problems, and international cultural and educational cooperations, a number of United Nations organs are engaged in the promotional activities for realization of economic, social and cultural rights. These various bodies such as the General Assembly, the Subcommission on Prevention of Discrimination and Protection of Minorities and the Commission on Status of Women are striving for implementation of economic, social and cultural rights. For monitoring the implementation of these rights, the Committee on Economic, Social and Cultural Rights has been established under the International Covenant on Economic, Social and Cultural Rights. Furthermore, there are several specialized agencies of the United Nations such as the UNESCO, Food and Agricultural Organization, World Health Organization and the International Labour Organization, which are engaged in the promotion of realization of economic, social and cultural rights. Enforceability of the economic, social and cultural rights. The economic, social and cultural rights and civil and political rights are interdependent and indivisible. This means that one set of rights does not have priority over the other, and one set of rights cannot be enjoyed in a meaningful way if the other set of rights is also not enjoyed. In the debates about the observance of human rights, the observance of economic and social rights is still receiving less attention than the observance of the civil and political rights. Perhaps this is caused by a failure to recognize phenomena such as poverty, malnutrition, illiteracy and unemployment as human rights problems. This is manifestly wrong. It needs a little imagination to see that the right to life, incorporated as one of the basic civil and political rights, is closely linked to the economic rights to food, housing and health care, among others. One of the common arguments against legally enshrining economic, social and cultural rights, particularly in legal circles, is the claim that such rights are not justiciable, that is, they cannot be interpreted and enforced by courts. This criticism is mostly due to the fact that very few legal systems have made provisions for the enforcement of economic, social and cultural rights such as the right to health or housing. This has created a perception that economic, social and cultural rights must be non-justifiable, a perception that is being increasingly challenged both in abstract as well as in practice. And perhaps there is no economic, social and cultural rights which could not be considered to possess at least some significant justifiable dimensions. Judicial responses. Rights stipulated in covenants on economic, social and cultural rights do not find place in Part 3 of the Constitution, which lays down the fundamental rights. Such rights are enshrined in Part 4 of the Constitution, which lays down the directive principles of state policy. Part 4 deals with the positive duties cast upon the states to achieve them. The significant difference between the fundamental rights and the directive principles is that while the former is enforceable before the courts of law, the latter is not justiciable, and therefore likely to remain unenforceable. As such, no legal action can be taken against the government in a court of law if it fails to follow any of these principles. However, the courts are required to interpret the laws in the light of the social and economic values set out by these directive principles. This proactive judicial attitude also manifestly highlighted the significance of the economic, social and cultural rights of citizens. The judiciary took upon itself the task of infusing into the constitutional provisions the spirit of social justice. Thus, it did in a series of cases, of which Maneka Gandhi vs. Union of India 1978 1 Supreme Court case 248 was a landmark. The case involved the refusal by the government to grant a passport to the petitioner, which thus restrained her liberty to travel. In answering the question whether this denial could be sustained without a pre-decisional hearing, the court proceeded to explain the scope and content of the right to life and liberty. In a departure from the earlier view, the court asserted the doctrine of substantive due process as integral to the chapter on fundamental rights and emanating from a collective understanding of the scheme underlying Article 14, the right to equality, Article 19, the freedoms, and Article 21, the right to life. The power of the court to strike down legislation was thus broadened to include critical examination of the substantive due process element in statutes. Once the court took a broader view of the scope and content of the fundamental rights to life and liberty, there was no looking back. Article 21 was interpreted to include a bundle of other incidental and integral rights, many of them in the nature of economic, social, cultural rights. In Francis Corelli Mullins versus the Administrator, Union Territory of Delhi, 1981 to Supreme Court Reporter 516, the court declared the right to life includes the right to live with human dignity and all that goes with it, namely, the bare necessities of life such as adequate nutrition, clothing, and shelter and facilities for reading, writing, and expressing oneself in diverse forms, freely moving about and mixing and coming with fellow human beings. The magnitude and components of these rights would depend upon the extent of economic development of the country, but it must, in any view of the matter, include the bare necessities of life and also the right to carry on such functions and activities as constitute the bare minimum expression of the human self. The combined effect of the expanded interpretation of the right to life and the use of PIL as a tool led the court into areas where there was a crying need for social justice. These were the areas where there was a direct interaction between law and poverty, as in the case of bonded labor and child labor, and crime and poverty, as in the case of under trials in jails. In reading several of these concomitants, right of dignity, living conditions, held into the ambit of the right to life, the court overcame the difficulty of justiciability of these as economic and social rights, which were hitherto in their manifestation as directive principle of state policies, considered unenforceable. In Olga Tellis versus Bombay Municipal Corporation, 1985-3 Supreme Court Case 545, the court held that the right to life included the right to livelihood. The petitioners contended that since they would be deprived of their livelihood if they were evicted from their slum and pavement dwellings, their eviction would be tantamount to deprivation of their life and hence be unconstitutional. The court, however, was not prepared to go that far. It denied the contention and said that no one has the right to make use of a public property for a private purpose without requisite authorization, and therefore it is erroneous to contend that pavement dwellers have the right to encroach upon pavements by constructing dwelling thereon. If a person puts up a dwelling on the pavement, whatever may be the economic compulsions behind such an act, his use of the pavement would become unauthorized. Later benches of the Supreme Court have followed the Olga Tellis dictum with approval. In Municipal Corporation of Delhi versus Gurnam Kaur, 1989-1 Supreme Court Case 101, the court held that the Municipal Corporation of Delhi had no legal obligation to provide pavement squatters alternative shops for rehabilitation, as the squatters had no legal enforceable rights. In Consumer Education and Research Center versus Union of India, 1995 3 Supreme Court Case 42, the court in the PIL tackled the problem of the health of workers in the asbestos industry. Noticing that long years of exposure to the harmful chemical could result in the debilitating asbestosis, the court mandated compulsory health insurance for every worker as enforcement of the worker's fundamental right to health. It is again in PIL that the court has had occasion to examine the quality of drugs and medicines being marketed in the country and even asked that some of them be banned. The question whether the right to education was a fundamental right and enforceable as such was answered by the Supreme Court in the affirmative in Mohini Jain v. State of Karnataka, 1992 3 Supreme Court Case 666. The correctness of this decision was examined by a larger bench of 5 judges in Unikrishnan J.P. v. State of Andhra Pradesh, 1993 1 Supreme Court Case 645. The occasion was a challenge by private medical and engineering colleges to state legislation regulating the charging of capitation fees from students seeking admission. The college management was seeking enforcement of their right to business. The court expressly denied this claim and proceeded to examine the nature of the right to education. The court refused to accept the non-enforceability of the directive principle of state policy. The court then proceeded to examine how this right would be enforceable and to what extent. It clarified the issue by stating that the right to education further means that a citizen has a right to call upon the state to provide educational facilities to him within the limits of its economic capacity and development. By saying so, we are not transferring Article 41 from Part 4 to Part 3. We are merely relying upon Article 41 to illustrate the content of the right to education flowing from Article 21. We cannot believe that any state would say that it need not provide education to its people even within the limits of its economic capacity and development. It goes without saying that the limits of economic capacity are, ordinarily speaking, matters within the subjective satisfaction of the state. In fact, the court had broken new ground in the matter of justiciability and enforceability of the directive principle of state policy. The economic, social and cultural rights are no less important than fundamental rights in the constitutional scheme. They are enforceable when they are projected as supplying the content of a fundamental rights, but not just by themselves. The judiciary will not be fettered by any apparent injunction in the Constitution against non-enforceability of the directive principle of state policy. It will, on the other hand, pin the state to its obligations towards the citizens by referring to the directive principle of state policy. Such obligation, the court had explained in the context of right to environment, can confer corresponding rights on the citizen. It need hardly be added that the duty cast on the state under Article 47 and 48A in particular of Part 4 of the Constitution is to be read as conferring a corresponding right on the citizens, and therefore the right under Article 21 at least must be read to include the same within its ambit. At this point of time, the effect of the quality of the environment on the life of the inhabitants is much too obvious to require any emphasis or elaboration. The economic, social and cultural rights that the directive principle of state policy symbolize can demonstrably be read as forming part of an enforceable regime of fundamental rights. What then is crucial is the will of the state to implement this constitutional mandate. The agenda of the state can be shaped to a considerable extent by creative and activist judiciary. The state has to be constantly reminded of its obligations and duties. The actual realization of the economic, social and cultural rights may be a long-drawn affair, but keeping it on the agenda is more than half that effort. The Indian judiciary has, through a combination of strategies, done just that. Conclusion. To conclude, the International Conference on Human Rights has pointed out that without full realization of economic, social and cultural rights, the implementation of civil and political rights was not possible. Being aware of this fact, the Commission on Human Rights expressed a deep concern in its resolution of 14 March 1985 for considerable gap prevailing in the implementation of economic, social and cultural rights in many countries of the world. Judicial enforcement of human rights is fundamental. A right without a remedy raises question of whether it is in fact a right at all. This is not to say that judicial enforcement is the only or indeed the best way of protecting economic, social and cultural rights. However, judicial enforcement has a clear role in developing our understanding of these rights, in affording remedies in cases of clear violations and in providing decisions on test cases which can lead to systematic institutional change to prevent violations of rights in the future.